The Inland Empire is a great area. You can dial us. You can reach us at 844-984-8414. That's the injury helpline. But if you're in Southern California, we also service all Southern California residents and all of residents in California. It's the law is the same across the entire state for workers' compensation. So if you live in California or you got hurt in California, you can reach us at 844-984-8414, dial the injury helpline. And you might have had a case that you had a long time ago, like in the last couple of years, and maybe not a long time ago, but you've had it for a while, and you haven't had a lawyer, or you had a lawyer, and the lawyer closed it, and you kept your medical care open. That's what we're discussing for episode number 34 of the Inland Empire Workers' Compensation Lawyer Livestream podcast, about reopening a claim after you've settled it by what we call a stipulation, which means you took your permanent disability, you took some money, and you left your medical care open. You continued to treat with workers' compensation. George, what are the rules pertaining to this thing? And if there's someone out there, what do they do if they've done this and now they want to do something more?
Yeah, Alex, I think this is great information for someone that's in the position that you described. They settled their claim via stipulations with request for award, right? They got an award issued by a judge from a final permanent disability finding. But I think that this is also great information for people that are interested in the possibility of resolving their claim, and they don't know whether they want to go with the compromise and release or a stipulation with a request for award. So even if you're in that position where you still haven't settled your claim, you need to know this information because you need to know what can happen after you've settled your claim. With one situation, nothing's going to happen. It's a done deal. You'll never be able to do anything. But with a different settlement type, you might be able to reopen your claim. So I think this is great information for people that have already settled their claim via stipulation with request for award, or for someone that's looking at options on how to settle their claim.
That's a good point.
So we're going to start off with you've settled your claim. You've received a final permanent disability finding, and this could be, Alex, from a primary treating physician, or you could have gone to a QME AME, right? So it doesn't have to be a QME AME. I would recommend that it at least be a QME or an AME. I don't like to go with primary treating physician finding a permanent disability, but you never know. It could be once again a case-by-case basis. Yeah. You could have a great primary treating physician.
Get that PTP, that treating physician's report, looked at by a lawyer.
Right. And you could have a great PTP, and they give you a great report, and it's to your favor to settle on that report, and everyone's in agreement. Now we're at a place where we settle from that report. It's a finding of permanent disability, and you're done. What does a permanent and stationary maximum medical improvement mean, Alex? For people out there, just let's review that.
Right. So if you've been injured at work and you've had medical treatment at some point, the doctors say, hey, that's the best that you're going to get. At that point in time, you're permanent and stationary. That's when your temporary disability benefits end, but that doesn't mean your medical care ends.
Right.
And that's where we're going with this, right?
Correct. And a finding of permanent and stationary and maximum medical improvement by either your PTP or QME AME. What that also means, Alex, is that they're not saying that your condition can't get worse or better. They're saying that within a year, your condition is unlikely to improve or get worse within that year. So it's not the final say so, but they're saying at this point, we've reached a point in this claim where no matter what medical treatment we bring, no matter what we do, the condition is not likely to improve or get worse. So now we're going to give you a final rating of disability.
So with someone who's had a stipulation, they've agreed to that rating of disability. Right. And within 5 years of the original date of injury, is that true? It's 5 years, they can reopen it.
They can reopen it, right. So although you've settled it based on your PTP QME report and there's a final PD given, that doesn't have to be the final permanent disability for your claim. You have 5 years to reopen that claim if your condition gets worse or if there's new and further disability. What could be new, right? It could be the same injury, but it's worsened, so further, or it could be maybe you hurt your right ankle, but because you have that permanent disability on your right ankle, you've been walking weird with your left ankle. Now that's a new and further disability caused by your original workers' compensation claim, right?
Absolutely. So if you're out there and you've continued to work, you've probably gotten worse. You might have an additional cumulative trauma claim. We've discussed that in prior videos. We'll put a link to what a cumulative trauma is. put the link up here. You can go and watch that video. But if you do have a situation where you've gotten worse, there's a potential that you could reopen your claim. This happens, if you're having ongoing medical treatment, the doctor thinks that they've made you permanent and stationary, but something else arises within 5 years that makes you suddenly surgical. Maybe you've been trying to tough it out and then things just change course after another year or two. The appeals board would give you that opportunity. Now, this isn't if you settled out by lump sum. No. This is if you settled out by stipulation and award.
Right. So this does not apply to a compromise and release. So the criteria to reopen, first of all, please remember, your date of injury is very important. It's 5 years from your original date of injury. Okay. So if you have taken 5 years on the claim by itself and then you close it, are you out of that window? You're going to be out of that window. It's a wrap. But you have to prove a couple things as well. You have to prove that you have a new and further disability that is stemming from your original injury, right? So it has to require proving some demonstrable change in your condition, overall health condition that's worsening or deteriorating your body parts that were set to be permanent and stationary when you entered into that stipulation with a request for award.
Absolutely. Yeah. So like if you were had you fractured your back and suddenly, a year later you stipulated and you said, okay, it's at this much permanent disability, but a year later it turns out that the fracture never fully healed and it's opening again and you suddenly need to have surgery on that.
Right.
That might be something that later develops that, causes you to have a new and further disability, or it just might be additional pain.
Yeah.
Something that doesn't require more.
Now, I do want to clarify this, Alex, because as we're talking, it's a question that came into my mind that our viewers might have. Well, what if it's 7 years down the line from the original date of injury, but my back did get worse and now I need additional surgery? So that means I can't get that additional surgery if I have a stip?
Well, you still would be entitled to the medical care for the rest of your life.
Right.
Whether or not you can enforce that, hire a lawyer, that could be difficult.
Right.
But you are entitled to the care and you could still potentially settle your case.
Yeah, right. But you're not entitled to an additional amount of PD. That's what I was getting at.
Right.
So even though you're having that surgery, you are entitled to that future medical care. It's within that settlement, within your stip, that for the rest of your life, for those body parts that are included in there, you're getting future medical care. Now, how easy is it going to be to get medical care from an insurance company? You might have to jump through some hoops, right? So that's a different topic, but you're entitled to it. However, my point was that even that extra amount of medical treatment and surgeries and whatever the case might be, if it's past that 5-year mark, you can get that treatment, you can get those surgeries, but you won't get any additional permanent disability rating. If you do it before the 5-year mark and you reopen your case, there's a possibility for an additional permanent disability rating, right? A new evaluation and additional permanent disability to be issued. So more money on your permanent disability.
Absolutely. So that's why we put together this video. If you're out there, you maybe had a lawyer, you maybe didn't have a lawyer, but you did sign something that says stipulation with request for award. You got some money, you put some body parts on that paper, and you have some future medical care. Or maybe you don't even know that you have future medical care, but you sign this document. You can call a lawyer right now and ask about your legal rights. Dial the injury helpline 844-984-8414 and get a free and confidential case evaluation with a practicing California workers' compensation lawyer. Either George Abuado or myself will come to the phone and give you that evaluation. Do you have anything else you want to add to this, George?
Final thoughts is that there are reasons for not reopening your claim, right? You can't reopen it if you thought the permanent disability given when you first signed your stipulation was unfair. So you signed your stipulation with a request for award, all parties are in agreement. 2 months down the line, you're like, listen, that hurt a lot, and I feel like I'm more injured than I was told I was, that I agreed to. I want another look at this. Can't do that,
But you could look.
I'm saying as a general rule, you can reopen it. You can say it's worse now after 2 months.
You don't need to have the medical evidence in existence at the time in order to get the case reopened. So right. I don't want to discourage any viewers. What you're saying is true. You can't just reopen it even if you don't have any more, but you might try because you might have said, oh, whoa, maybe I settled by stipulation and award. I didn't have a lawyer, and this happened. I actually represent several people who they stipulated the case. And now they've come to me and we're reopening it because we want a cash settlement.
Right.
Or maybe you don't have a new and further. Maybe it's been more than 5 years, but you continue to work for the same employer. Maybe you have a knee injury from 1995 and you still work there. Now it's time to retire. It's been another 25 years and you haven't had any medical care, but it's your knee's killing you.
Right.
You can't reopen that old claim for new and further from 25 years ago.
It's a new injury.
But you certainly have a new cumulative trauma injury.
Right.
So let's not discourage anybody. But yes, that's true. You might not end up with any more permanent disability, you know, but you maybe still try to reopen it.
Yeah, no, I love that, Alex. And thank you for bringing that up because, you know, that proves the point that every claim is different and you need an evaluation, because I gave out general information. If they just heard that, they might think, no, well, I'm not going to try to do anything about it. But you brought up very good points and you brought up exceptions where they should come talk to us, right? So, you know, there's a million things to discuss and things could change like that. So what you should do is definitely talk to an attorney, right? The last thing is you can't just open it because you felt you want another bite at the apple. That usually with, you know, disability payments, with any type of payments made to you, with any type of benefits, you can't just have a second bite. Everything we discussed prior to this needs to happen before you can reopen. And as Alex mentioned, there's a lot of exceptions, and he makes really great points. But you can't, just because you didn't like the outcome, you can't just say, I didn't like the outcome of that.
Be very careful before you sign those documents. Because
Definitely.
Once you agree, then you stipulated to a permanent and stationary date, so that's bye-bye temporary disability payments.
Right.
You might get more permanent disability, but if you need another surgery, maybe you get state disability, something we've discussed on this channel before. It's not something that George and I formally represent people doing, but we also help people fill out the paperwork for state disability, get them over to the doctor to help get you certified if your employer's not paying while we do fight your claims. So there's other things we help with. It's not just that you get an advocate for your workers' compensation claim. You get a counselor to help you make the best decisions so that you hopefully make it through.
Definitely. Great points, Alex. I think that's great information for our viewers. And that was episode 34.
It's episode 34 of the Inland Empire Workers' Compensation Lawyer Livestream Podcast. We'll be back again next week.
I love it.
Episode 35.